everyone. I welcome you all to this alternative dispute resolution and arbitration course. This is one of the important course in today's world that one can by itself get a very independent and complete career because the range and level of arbitration or alternative dispute resolution expanding throughout the world is quite amazing. And the same kind of reflection is experienced in the context of Bangladesh, where we see a largest number of laws are being reformed in order to comply with international form of arbitrations or in order to comply with what other countries are following. Now, the question is why the range of arbitration has been expanding within the domestic or international law. One of the fundamental reason, if I talk about the context of Bangladesh, about why alternative dispute resolution is being attracted and amended, included under the law, is the requirements and urge of the time being to make sure that we are capable of ensuring access to justice to all, regardless of the social or official status of the individuals. Now, access to justice is one of the fundamental foundation on the basis of which uh, alternative dispute resolutions are developed. This is what my hypothesis for this lecture is. It is to be noted here that alternative dispute resolution is quite opposing to the idea of adversarial system. And when we will be looking at the history of dispute resolution or settlement of dispute in the context of our society from time what you call Pal, Shen, Mughal, Sultanate, and then British. We will have some classes about the historical aspects of dispute resolution. So when we look at that, what we see here is that the adversarial system, which today follow by our courts, have not been a culturally attached system before the British installment in our society to the alien legal system. However, in last 200 years around, what we see is that the system has largely and mostly been adversarial. So, in the nature of adversarial, it is happened that a party is supposed to bring certain arguments and points for his claims, which are very much, you know, being what you call opposed strongly and denied by the other party. And in such a strong assertion or claim and denial by the other side, the system or procedure of the dispute settlement continues. And in this continuous process of dispute settlement, what we experience is that the parties, from the beginning of the dispute till the conclusion or implementation of the judgment of the court, have an attitude of adversary among themselves. One party versus other party. That's why if you see the name of the cases, what our courts are recording, and the way we read the cases, it is Mr. A versus Miss Y. So this versus system has been a continuous process in our society for more than centuries. Uh, but What my argument here is that the inauguration and continuous inclusion of alternative dispute resolution in the system of adversariality has actually been a kind of opposite idea of adversarial system within the legal system of our society. What I simply highlight is that alternative dispute resolution is being included in our laws uh, as an opposite idea to the adversarial system, and that opposite idea of adversarial system is being expanded day by day. I will be trying to explain the whole concept of why and how ADR mechanisms alternative to the or opposite to the idea of adversarial. And I think we will understand that once we will go through the laws of ours with relevant sections. If we go through, perhaps then things will automatically be clear to us. However, as I said at the very beginning, that access to justice has been the vital goal for the state to ensure that it is implemented and ensured in the society. And now, in the adversarial system, there were many challenges, and one of the challenges that the poor could not get relief from the court because they don't have capacity or financial support to bring the dispute before the court. This is one idea. Another idea or challenge in the adversarial system about access to justice is that the procedure is so lengthy, particularly land title related disputes, which takes time for more than a generation to continue with and carry on the suit. Therefore, how far in such prolonged continuation of the suit a party can be said that the state has been able to ensure access to justice for them? Then the question comes about, does the access to justice mean that the parties can get the court facility, or access to justice means the parties can get the justice within the predictable and reasonable time period? So these are all thoughts which clouds in the mind of a learner, and I think which should trigger to all the young individuals who would like to look into this particular area and to explore more. So, my next part of the lecture and subsequent parts will have exactly the same explanations about access to justice. But in order to sum up this part, what I'd like to highlight is that access to justice is the fundamental reason why ADR mechanisms are incorporated in particularly the context of Bangladesh legal system. And that is what the hypothesis is, and that is what I believe. But certainly, when we go through the mechanisms and nitty gritty of the ADRs in our laws, we may find that there are some challenges within the ADR itself as well. But of course, that is there. But before that, I think it's important that we look at the concept of access to justice first, and thereby look into whether ADR is really something which will complement to ensure access to justice. Thank you very much for your concentration.